service for him for Milwaukee County Criminal Session. The Honorable Lawrence C. Grant, Jr. presiding. Silence is commanded. You may be seated.
Case number F912542, State of Wisconsin versus Jeffrey Dahmer.
May we have the appearances for the record, please?
E. Michael McCann, District Attorney in Milwaukee County for the state of Wisconsin. Assisting me at council table is Assistant District Attorney Carol White. To my left, to her left is the City of Milwaukee Police Lieutenant Kenneth Moyler, and to his left is Assistant District Attorney Greg O'Mara.
Good morning, Your Honor. Jeffrey Dahmer appears in his own person and by his attorneys Gerald P. Boyle, Wendy Patricus, Ellen Ryan, and Scott Hansen.
We're here for a final pretrial conference and motion hearing. How do we wish to proceed?
I have filed certain motions before this court, and I would like to tell the court just generally what I intend on doing if the court will allow me to do it. I have prepared a very lengthy statement, a copy of which I have prepared for the court to read along as I am reading it. I think it's absolutely necessary that it be read in full. I have made copies available to Mr. McCann and his staff this morning. I have given copies to Mr. Witkowiak, and I would ask leave of the court to allow him to pass them out to the media as I'm reading them, because it would be very hard to understand some of the things I'm saying, and it will help if they have an opportunity to read the words. I have also here, Judge, a guilty plea questionnaire form that I will have marked as an exhibit and to present to the court this morning. I have made copies of that available to Mr. McCann, and if the court will allow me to proceed that way, what I will do is to mark both of these items for the court and then to proceed to read the written statement that I have stated that I think will cover all of the matters before Your Honor this morning.
Okay, first of all, let's deal with the matter of the prepared statement. Mr. McCann, Mr. Boyle advises the court that he has a prepared statement that he would like to read to the court, and he would like to have it in the hands of the media as he is reading it to the court. Do you have any objection to that?
No objection.
Okay, then it may be distributed.
Your Honor, I have prepared a binder containing 15 guilty plea questionnaires, and I would like to ask that it be marked as an exhibit and be given to the court, because as I'm reading this prepared statement, it will clear up how this was formulated to be presented to the court this morning.
Very well. You want it all marked as Exhibit 1?
Yes. Okay. I think the binder can be marked as exhibit. Okay. The statement that I'm going to read, Judge, I am now presenting to the clerk for you to go along with, to be prepared to read rather than to listen. Your Honor, the following statement is necessary to make for the purposes of the record. I feel it necessary to make this somewhat lengthy statement so that the public will know through the media what is happening in this case. As the court well knows, there is an enormous interest in State versus Dahmer. Without a full and complete explanation as to what is happening here today, there will be speculation that could cause confusion and divert attention from the real issue in this case, which is the mental condition of Mr. Dahmer at the time of the commission of these offenses. Thus, the defendant, Jeffrey Dahmer, is prepared to change his plea today and enter a plea of guilty to each and every count of the information, that being guilty to 2 counts of first-degree murder and 13 counts of first-degree intentional homicide. The reason for the 2 denominations of such crimes is because in January of 1989, the law was changed to reflect the distinction, and parole eligibility was changed in July of 1988. So as a result of that, we had to somewhat change these guilty plea questionnaires to reflect that so that the proper data would be contained therein. There has been a different nomenclature for really the same crime of first-degree murder, and we'll get into that. That's all in the booklet that you have in front of you, as I'll explain. In essence, Your Honor, the defendant is ready to change his plea to all the homicide counts that have been filed against him. What we have done to effectuate that is to have a guilty plea questionnaire prepared for each of the homicides. We have attached to the questionnaire a copy of the charge for that murder count and the statement in the criminal complaint that reflects the facts supporting that charge. There is then contained therein, and that's in the booklet that you have in front of you, Your Honor, and it's exhibit number 1. There is then contained therein a signed statement by Mr. Dahmer reflecting that he stipulates that the factual allegations contained in the criminal complaint supporting that individual charge is substantially true and correct and will allow the court to accept those facts as proven to prove up the guilty plea. That statement is signed by Mr. Dahmer on each and every one of the attachments to the guilty plea questionnaire. We also attach the relevant law as it relates to punishment because, as the court well knows, from July of '88, parole eligibility changed, and the individual court can set the term of parole eligibility. It's my understanding that the guilty plea questionnaire must reflect all matters relating to the defendant's understanding of not only what he is being charged with and what he is pleading guilty to, but the potential punishment. So as a result of that, we attached the law and it was explained to him so that there would be no question and the court would not have to make an in-depth inquiry about it. Mr. Dahmer is also aware that each life sentence, carries a life sentence which is mandatory, and they may be consecutive to each other, and that parole eligibility could be likewise consecutive to each other, which in fact means that Mr. Dahmer knows that the 2 first-degree murder counts could be concurrent parole eligibility or consecutive parole eligibility, and therefore parole eligibility could then be 13 years and 6 months or 27 years, while the other counts could carry no parole eligibility or a term of years well in excess of 20 years eligibility, and that each of the parole eligibility dates could be consecutive to each other. I felt it was our responsibility to make sure that Mr. Dahmer knew absolutely that by pleading guilty to these charges that he could in effect get 15 consecutive life sentences, and as to 13 of them, the court could in fact impose parole eligibility date far in advance of his natural life for all practical purposes, make those all consecutive to each other, and I thought it necessary that he know that. There also exists a count of habitual criminality to each and every count, which could increase the individual sentences by 10 years. We have a guilty plea questionnaire filled out for that, but in reality, one does not plead to habitual criminality. We include it so we could demonstrate to the court that Mr. Dahmer knows about that fact when he enters these pleas. Each guilty plea questionnaire reflects my name and that of my associate, Ellen Ryan, because she has worked long and vigorously on this matter, and was she who went over each and every questionnaire with Mr. Dahmer and had him initial each paragraph of each questionnaire as is reflected in the exhibit before you. Also, she read to him the criminal complaint and the facts in support of the same. I've had many discussions with Mr. Dahmer about these matters. Yesterday, I went through the entire matter with him. I read to him a guilty plea questionnaire, which obviously has been read to him by Ms. Ryan on each of the 15 charged homicides, and asked him if he understood each aspect of the same. I also asked him if it was necessary to read the same questionnaire another 14 times, and he indicated it was not, because each had been read to him by Ms. Ryan. He has initialed, as you can see, each paragraph of each questionnaire after he read the same and/or it was read to him. He verified that he was made aware of the facts that were attached and that he agreed to allow those facts to act as the basis for the taking of the plea. Many times, the facts of each homicide were discussed with Mr. Dahmer by myself, Ms. Patricus, and especially Ms. Ryan. As a matter of fact, Ms. Ryan was hired to serve my purposes in working on this matter, on this case and only this case. She went through each and every page of the discovery with Mr. Dahmer. The number of pages exceeded 8,500, and every page was discussed with Mr. Dahmer and initialed by him. I have explained to Mr. Dahmer why it is necessary to make such a careful record of this and why I'm expressing these matters publicly. I believe that when a lawyer makes major decisions in a criminal case, he should make a record of what he is doing and why. That is for the protection of the record and for an explanation in case the matter is reviewed by another court or an appellate court. Likewise, any lawyer reviewing this transcript will have written documentation of the reasons behind the decisions that were made. This, I believe, is in the best tradition of the criminal justice system. Mr. Dahmer understands and agrees. Frankly, Your Honor, Mr. Dahmer has been exceptionally cooperative with my office in order to ensure that this matter proceed properly. I want to emphasize that the decision to plead guilty is Mr. Dahmer's. It is not mine. I concur that he is doing the appropriate thing in pleading guilty. This case is about his mental condition. That matter continues because we have not abandoned the plea of not guilty by reason of mental disease or defect. The insanity plea is not waived by the entry of a guilty plea. This change of plea only goes to the guilt phase. Another matter that should be inserted here is the matter of the confession. It is clear that many of these homicides could not have been proven or even known about without the confession of the defendant, Jeffrey Dahmer. I say that because one of the ways of firming up the factual basis for the taking of the plea would be to attach the confession and have that serve as the basis. I am not inclined to do that and would resist that because then the confession would become a matter of public record and available for publication. That would definitely affect our ability to have a fair trial on the insanity issue, and I see no reason that we cannot proceed as I have outlined. I can say unequivocally that the defendant has read and has had read to him the entire confession which he had given to the Milwaukee Police Department. That confession is substantially true and correct except for some refinements that will be brought out at trial. I am, however, most hesitant to get into such matters at this time because of the pretrial publicity problem. I also wish to indicate to the court that in a case such as this with these very peculiar facts, there are some variances with the proof as to the cause of death. Because of the time lapse and the anatomical problems concerning the victim, the proof of the cause of death is different than in most homicide cases. I am comfortable that the elements of each and every one of the homicides are provable beyond a reasonable doubt. I am confident that the defendants pleading guilty to these individual homicides on the basis of what is known as to the cause of death complies with what is necessary to prove in a first-degree murder case or a first-degree intentional homicide case as it is now called. Some of the information given to us from the medical examiner's office is different than in many cases, but we are satisfied that it complies with what the law requires for proof purposes. There is no need to go into anything further relative to this matter because in any event, my client has had this explained to him and wants to waive any challenge to this concept of nexus between the act and the cause of death. I feel it is legally appropriate to move forward on these charges on the basis of the information given to us by the medical examiner's office. What I am saying is that it is required that the state be able to prove each and every element of the crime beyond a reasonable doubt. I am satisfied that the state is able to prove each and every element beyond a reasonable doubt, and I have so advised my client. This morning, all of the jury instructions had been read to him before. Once again, they were read to him this morning as to both of those charges, so he has also had the jury instructions read to him as to what the elements are and what need be proven. The state, in my opinion, is able to prove beyond a reasonable doubt that my client caused the death of the respective victim with intent to cause the death of said victim. He wishes, therefore, to plead guilty as I have already stated. Once again, it is my client's sole decision to plead. No promises nor threats have been made to get him to do that. I am prepared even now to go to trial on the guilt phase if Mr. Dahmer so chooses. He does not. I therefore ask the court to accept the change of plea. There need be an explanation of 4 of the charges, actually 2 of the charges that will have to be refined, but I shall do that after the jury in this matter is sequestered. It has to do with Mr. Dahmer's conduct relative to 4 of the victims. I do not wish to discuss it now as I do not think it in any way affects his pleading guilty. The defendant, as I said, has had the jury instructions read to him relative to the crime that he is pleading to, and he accepts the fact that he will be found guilty of the same based upon his confession, the physical corroboration, and the testimony of the medical examiner's office. The concept of the natural and probable consequences of one act was gone over by me with the defendant to have him understand that while one's intent may be one thing, one is also responsible for other occurrences if the same be the natural and probable consequences of one's act. Before the court does act on my motion to change the plea, there are 3 other matters that need to be discussed. Because there are 3 motions presently before the court, 2 must be dealt with before the change of plea can be accepted. I therefore wish to address that matter at this time. As the court well knows, it is the function of a trial lawyer to make sure that every viable motion be filed on behalf of the defendant unless the defendant wishes to waive the same. Even if the client wishes to waive such motions, the lawyer may be compelled to argue against such waiver and be required to tell a court that the defendant is waiving a right to a motion that the lawyer feels he should not be waiving. Obviously, the easiest thing a lawyer can do is to file every conceivable motion and let the court decide the same. If a lawyer does that, he cannot ever be second-guessed as to why he did not file such motion or have such motion heard. That, to me, is an abomination of the criminal justice system and is bad practice. As the court well knows, some, albeit few, appellate lawyers are using ineffective assistance of counsel to get a case back in court. Most of these claims are absurd. In view of the appellate cases in Wisconsin will bear out what I've just said. One of the ways of obviating ineffective assistance is to file a motion, let the matter proceed, and have the court rule. Then the trial lawyer need never be concerned about the claim of ineffective assistance. The criminal justice system deserves better than that. I make these introductory statements because Mr. Dahmer is today withdrawing his motions to suppress the physical evidence and to suppress the confession. I agree with that decision and will so move. Such decision is based upon his own desires relative to these motions and based upon my counsel. I have spent literally more hours considering these motions than any other motions that I have dealt with in the 26 years I've been practicing criminal law, both as a former member of the district attorney's office and as a private practitioner, concentrating on criminal law. There is a real reason for that. First off, there is a search without a warrant, which in and of itself raises a lot of red flags. A lawyer acts with pearl when he waives that motion. Also, in the case, for the most part, is based on the confession of the defendant, and where the lawyer knows that most of what the prosecutor has as proof is the confession of the defendant, then the lawyer must scrutinize the matter with a fine-tooth comb to make sure that the defendant's rights were not violated. It is because of what I have just said that there were requests for time to file these motions because of the enormous amount of discovery that had to be reviewed before the decision could be made. As I proceeded in determining the matter of motions, I made a decision that only 3 motions had any merit at all, and those were the motions that were ultimately filed. 1, motion to suppress physical evidence. 2, motion to suppress statements. And 3, motion for a change of the place of trial. For the present, I will deal only with the 2 suppression motions. First off, my client, Mr. Dahmer, some time ago told me that he did not want to file such motions. I could not allow him to make that decision until I was satisfied that he was doing the right thing. I suggested to him that I file the 2 viable suppression motions and do some further research and then check out a few matters before the final decision would be made. He agreed. Prior to filing the motions, I had 3 different individuals do independent research on the issues I felt existed. My associate Ellen Ryan, myself, and another lawyer looked at the matters relating to the search. 2 of us looked at the matters of the confession, both from the good child Miranda perspective and from the suppression if there existed improper police conduct relative to the search. As the court well knows, the axiom that any search not accompanied by a search warrant is per se unconstitutional, and the state best be prepared to justify it under an exception, or else there will be, as a matter of law, a suppression of said evidence. Further, if the search was defective, the resulting confession could likewise be excluded, and the state might find itself without any case whatsoever. In the past, when such an occurrence takes place, the community at large becomes irate and claims that a person got off because of a technicality. They do that rather than point to bad police work that caused the alleged technicality to exist in the first place. A person's constitutional rights can never be considered a technicality, and when the same are violated, there should be some corrective action taken. A lawyer has a sworn obligation to raise such questions if the same exists. So we arrive at a very serious point of departure when we have a search without a warrant and a confession that follows, knowing that an investigation of the same has to take place to determine whether or not the search can be justified under an exception, and then whether or not the confession is sufficiently antiseptic in a constitutional sense so as to allow its admission to the evidence. That is what we have been doing these last few months. As I said to Mr. Dahmer yesterday, the easiest thing for me to do at the motion hearing today is to sit in court and let Mr. McCann satisfy the court that the search was within one of the exceptions and the resulting confession is constitutionally antiseptic. I shall not do that because I do not feel the motions are viable. I see no reason to go through exercises in futility in order to obviate challenges later on. I have taught that the only motions that should be brought into court are those that have merit. These motions, after final review, are not meritorious. I make this statement because this matter may be reviewed by another lawyer someday or an appellate court, which may just want this question answered. Hopefully, this record will now contain the answer. Mr. Dahmer has directed me to withdraw the 2 motions to suppress. I agree with that decision. I have researched the matter in every possible way. I feel that there are 2 main exceptions that the state could utilize to justify the search of Mr. Dahmer's apartment. One is consent. There is absolutely no question in my mind, based upon my conversations with Mr. Dahmer, that he did give consent for the police to enter his bedroom. It was in that bedroom where the officers found the pictures that caused this whole matter to unravel. Also, there was a weapon in the form of a knife that was under Mr. Dahmer's bed, which knife was used against the person of Tracy Edwards. Mr. Edwards told the police about that knife, so the search for weapons and a search incident to a lawful arrest would be 2 other bases for the said exceptions to the warrantless search. Another basis would be exigent circumstances because of potential health problems. In any event, after reviewing all of the police reports, after talking with Mr. Dahmer, I became convinced that the state could find an exception to allow the physical evidence. But still not satisfied, I saw a need to talk to Tracy Edwards, the man who escaped from Mr. Dahmer's apartment and returned with the police. Although I wanted to meet with Mr. Edwards and his lawyer personally, I was unable to do so because Mr. Edwards and his attorney were away during the Christmas holidays. On January the 2nd, I had a conference call with Mr. Edwards and his lawyer and learned through that conversation and indeed what I thought to be the facts about the incident at the apartment were confirmed. I determined that as a result of that conversation that there was a consensual search of the bedroom and the taking of the evidence, albeit not all evidence in the apartment, was appropriate. I feel that a consensual search would have been found by this court after hearing the evidence. I further found that the state would have been able to prevail on a search incident to a lawful arrest. It is interesting to note that the police reports of this matter are somewhat different than the facts that I have learned, but in any event, the differences would not have negated the finding that I feel would have come forth from the testimony. The intrusion into the apartment was lawful. The arrest was lawful. The entry into Mr. Dahmer's apartment was lawful. The recovery of the weapon was lawful. The taking of the pictures showing the victim and the carnage caused to some was lawful. The opening of the refrigerator was questionable. The taking of the body parts from the bedroom was appropriate. The search of other parts of the apartment would seem to be, under present law, permissible. The later written consent by Mr. Dahmer, which came a few hours later, could have been challenged, but probably the same would have been a pale victory and would not have really affected the outcome of the admission of sufficient evidence to convict Mr. Dahmer of each and every charge crime. I wish to make it clear that this statement about my discussions with Mr. Dahmer concerning his motions is not all-inclusive. Many hours of conversations took place with Mr. Dahmer, leading to the decisions that are made here this morning. This contains only a brief synopsis of our discussions. This, then, is an introduction to my argument with Mr. Dahmer's decision to withdraw his motion to suppress the confession. There is absolutely no question in my mind whatsoever that the confession is constitutionally antiseptic unless it could be suppressed as a result of an unlawful search. Since I have concluded it cannot be suppressed for that reason, I then look to whether or not it falls under the good child Miranda basis. I could be held to be proffering a frivolous motion if I were to suggest that Mr. Dahmer's confession was not freely and knowingly given to the police. When first retained, and after having instructed my associate to go to the Detective Bureau to talk to Mr. Dahmer, I was advised he did not want a lawyer, and he did not want to even talk to a lawyer, but wanted to continue confessing. I then contacted a deputy inspector and suggested to him that the better practice would be for that message to be delivered personally to my associate and not through a department intermediate. The inspector agreed. My associate was carrying instructions for me as I was out of town, and I told her to tell Mr. Dahmer that if indeed he wanted to continue to waive his Fifth Amendment right, it was his privilege and not mine nor my associates, but that I felt that if that's what he wanted to do, he would still be better off having an attorney with him when he was doing it for the purpose of making sure that his rights were protected. He agreed, and thereafter someone from my office was normally present for these interviews. Before the first few such interviews, we had Mr. Dahmer sign a document saying that his continuing to confess is what he wanted to do, in spite of the fact that we advised him of the effect of that decision. Also, I had Dr. Ken Smale examine Mr. Dahmer to make sure that he was competent to make the decision to continue to waive his Fifth Amendment right, that he knew what he was doing and the effect of what he was doing. I was advised that he was competent, and I determined from my own experience that he was competent. In any event, most of his confession as to his involvement in the homicides was already a matter of record, and all the defendant was doing was continuing to assist the police in the identification process. At no time did we see any evidence whatsoever of police impropriety. I determined from my discussions with Mr. Dahmer that at all times he was treated with courtesy and dignity by the detectives assigned to take the confession, to wit, Detectives Murphy and Kennedy. Mr. Dahmer's requests for food, drink, and cigarettes were complied with. He was not deprived of sleep. As a matter of fact, he summoned the police on a number of occasions to continue the discussions. He furthermore talked to them without our being present because that is what he wanted to do. Whenever he wanted to talk to police without first consulting us, the detectives would call us so we could be present. Your Honor, I see no evidence whatsoever that I could conjure up to support an argument that there was a violation of Miranda Goodchild. Mr. Dahmer was at all times advised of his rights. I know that because he told me so. Mr. Dahmer has emphatically told me that he wishes to withdraw these motions. I must comply with that request unless I'm unable to justify such a decision. I know of no reasons whatsoever to suggest that Mr. Dahmer is wrong with his choice, and I therefore must comply with his request because, amongst other reasons, I agree with that decision. Furthermore, Mr. Dahmer does not want to testify at these motion hearings in spite of the fact that what he would say could not be used at his trial or, in my opinion, either phase of his trial except under the well-known exception of impeachment. Maybe in the second phase, some of his motion testimony could in some way or another find itself in the record, but in any event, that is not a matter that need be gone into because Mr. Dahmer does not want to testify. On the issue of consensual search, it would be more than difficult to posture an argument without Mr. Dahmer's testimony, in spite of the fact that the lack of his testimony would not be dispositive of the motion, in my opinion. It would just make the burden easier for the state because there would be nothing to challenge the claim of consent if that would be the argument to justify the search. Incidentally, Mr. Edwards would support the consent based upon my discussions with Mr. Edwards. I think consent exists even if the police that were present didn't think that consent was the sole basis for going into the bedroom. Likewise, without the defendant testifying, the state would have a strong argument on the search incident to a lawful arrest. It is for all of the above that I support Mr. Dahmer's decision to withdraw the two aforementioned suppression motions. I asked Mr. Dahmer yesterday a hypothetical question. The question was, if I were able to guarantee him that I could suppress all of the physical evidence and also block the confession, thereby affecting the state's case, would he still want me to withdraw the motion? His answer was an emphatic yes. I wanted to put the matter in perspective because of his decision to withdraw the motions. I want to briefly discuss the Anderson case about attenuation, which I feel is likewise dispositive of the confession issue. I shall not recount that reasoning here, but will orally explain the same. On December the 11th, 1991, case number 90-01-24-CR, State of Wisconsin, plaintiff, respondent, petitioner versus Scott C. Anderson, defendant, appellant. A review of a decision of the Court of Appeals, which reversed the Court of Appeals decision, written by Justice Louis Ceci, goes into this entire matter of a confession that takes place within a period of time after an unlawful or illegal search. The part that is clear and that is most important here is page 7 in the slip of opinion that I have. The court said the defendant was given Miranda warnings and signed a waiver of constitutional rights for him prior to his statement. These facts weigh in favor of finding that the statement and resulting search were voluntarily and sufficiently attenuated from the illegal searches. However, the presence of Miranda warnings alone does not cause a statement to be sufficiently attenuated so as to purge it of the taint of the illegal action, citing Brown 422 U.S. at 603. There are other factors that must be considered in determining the question of attenuation. These are the temporal proximity of the official misconduct and the confession, the presence of intervening circumstances, and the purpose and flagrancy of the official misconduct. The court goes on then to analyze them, and I submit to you that taking all of the facts that one could conjure up to make an argument to stop this confession from coming in. Clearly, under Anderson, the confession would come in. So therefore, that is a most recent enlightenment from our Supreme Court telling us that our attempts to make any such argument in this court would be entirely frivolous, in my opinion. I would also like to say that our defense team has done everything possible to put a lid on the horrific aspect of this case. I am most impressed with the conduct of the District Attorney's Office and the Police Department in doing the same thing. The memories of these very unfortunate victims need not be subjected to descriptions of conduct that is, to say the least, incredibly revolting. I could not be a party to a parade of physical evidence being brought into a courtroom because of a futile motion to suppress, when the obvious outcome of that would be nothing more than to create a horror story of infinite proportion. Such would only be done if it were necessary. It should never be done just so a lawyer won't have to worry about the criticism for his decision. I will accept such criticism, but I can't believe any responsible lawyer sitting in my shoes would do anything other than what I am doing here. The families of these poor victims have suffered enough. This community has been likewise embarrassed because this unfortunate tragedy has taken place in the city. It is time for the right decisions to be made, and I accept the responsibility for making them. I wish to advise the court that this matter will proceed only on the insanity proposition. We will be prepared to start on the 27th. Some discussions about procedure will have to take place between the court and Mr. McCann and his staff, and of course myself and my staff, but I am sure there will be relatively few, if any, problems in arriving at a proper way of proceeding. I wish to address the one remaining motion, but I shall do so without memorializing my thoughts on paper. The reason is that as I write this the night before the hearing, I have decided that this motion can be argued orally without it being first written. As I have decided to have this statement reproduced in order to save myself from having to paraphrase it when this hearing ends, when we shall be besieged with questions by the press, I felt that since the last motion is quite simple, I should discuss that orally and not reduce my thoughts to writing. Your Honor, I apologize for the length of this statement, but I have thought long and hard about the necessity to do so. I feel that this is probably the most major case in the history of the state. Pray that no such type of situation may ever come again. I'm told there are 50 media entities present here today. I'm told there are in excess of 6 million viewers of Court TV which may be watching these proceedings. I'm told that the local TV media is carrying the matter live and the national TV is likewise broadcasting it. I have received countless media requests this last week. I have told everyone that I will say nothing until I speak to Your Honor in court today. But in fairness to the media and to the public at large, I have reproduced this statement for the media's perusal to hopefully assist them in recounting to the public what is happening in this case, so there are no false impressions as to the reasons for the decisions that have been made by Mr. Dahmer and myself. I have made copies of these remarks available to press. Your Honor, I would like now, if the court would, to ask Mr. Dahmer if everything that I have said in here today is substantially true and correct. And I would also like to tell the court a couple of other things, that Dr. Ken Smale was with my associate Ellen Ryan and Mr. Dahmer on Friday as the guilty plea questionnaires were being gone over. He is of the opinion, and he can express it on the record, that Mr. Dahmer was indeed competent to understand the nature of the proceedings against him and to assist us in his own defense, that he was competent to waive the rights that he has waived, that he is presently competent in this courtroom as he sits here today. And I would also like to tell the court that this statement was gone over with by Mr. Dahmer, and he has given me authorization to make all of the statements that I made in here for the purposes of crystallizing the issue, and the only issue in this case, and that is what his mental responsibility was at the time of the commission of the offense. So I'd ask the court to make inquiry as to whether those things that I've said and those things that I've attributed to Mr. Dahmer are true and correct, both to satisfy the court and the district attorney and for the purpose of the record, not in any way to help me have some kind of corroboration of what I've said. As I said, I will accept everything that I've done because I know that what I have done is done in the proper aims of the criminal justice system. So with that in mind, and after the court makes whatever inquiries it wishes to make and whether it decides it wants to take these pleas this morning, which is entirely up to the court, I would then be prepared to argue the only remaining matter before the court, which is the continuation of the discussion on the motion for the change of place of trial. Thank you, Your Honor.
Okay, I think we should first deal with the withdrawal of these motions.
Yes, sir.
Secondly, we should go on to the matter of the taking of the pleas. And thirdly, we should then discuss the remaining motion, which has to do with the conduct of the trial itself, which takes place on the 27th. So, for Mr. Dahmer, you've heard your attorney address the court. Do you feel that you have understood everything that he has said?
Yes, Your Honor.
Do you agree with what he has said?
Yes, I do.
Now, he's asked to withdraw two motions to suppress. One to suppress physical evidence, the other to suppress statements. Are you satisfied that he's fully advised you as to your rights in regard to those motions?
Yes, he has, Your Honor.
In understanding those rights, is it your desire that those motions be withdrawn?
Yes, it is.
Mr. McCann, do you have anything you want to add at this point?
No, I do not, Your Honor. I assume the court will inquire as to whether threats or promises have been made and so on.
Anybody made any threats or promises to you in regard to this?
No, I haven't, Your Honor.
You're doing this, is that correct, that you're doing this of your own free will?
Yes, I'm doing this voluntarily.
Court will allow the motions to be withdrawn. The next matter is the matter of the guilty pleas, and it is my understanding, sir, from what your attorney has told me, that you desire to change your plea of not guilty to guilty as to each and every one of the various counts in the information. Is that correct?
That's correct, Your Honor.
And it is the understanding, of course, that the plea of not guilty by reason of mental disease or defect remains. You understand that, sir?
Yes, I do.
Now, Mr. Boyle, this is undoubtedly repetitious, but just so we have our record together, let me inquire of you. Have you indeed advised your client of the elements of each and every one of these offenses?
I have, as have my two associates, Your Honor.
Okay. Mr. Dahmer, has your lawyer told you what the state would have to prove in order to establish your guilt? Sir, I have to have a verbal response.
Yes.
Let me explain that we have a young lady here that's taking everything down that's being said. We have to have this all in a verbal manner so that other lawyers and other judges can review what we're doing here today. Now, sir, as a part of that, did he explain to you that there are certain parts or elements of the offense that have to be proven?
Yes, he did.
Now, I believe Mr. Boyle told me that he went over the jury instructions with you. Is that correct?
That's right, Your Honor.
Are you satisfied that you fully understand all of these things?
Yes, I do.
Court then finds that the defendant understands the nature of the offenses that he is charged with. Now, sir, as to each count, your lawyer has prepared a form that we call a guilty plea questionnaire and waiver of rights form. Have you gone over each and every one of those forms with one or more of your lawyers? Mr. Boyle, have you yourself gone over each one of these with him?
I have gone over the guilty plea questionnaires with a guilty plea questionnaire and what it contains with Mr. Dahmer on 3 occasions. I then again went through the guilty plea questionnaire that was made out by Mr. Dahmer relative to count number 1, which is tabbed as 1 in the book that you have. As you can see on all 15 guilty plea questionnaires, at the beginning of each paragraph are the initials JD. I have certified within my discussion with Mr. Dahmer that in fact he did initial each and every paragraph of every one of the 15 guilty plea questionnaires in the presence of my associate Ellen Ryan. I asked him if he wanted me to reread the 15 guilty plea questionnaires and say the same thing 14 more times. He told me that would be a waste of time. His signature is on each and every guilty plea questionnaire, and I have discussed the elements of each and every one of these crimes with him, as have both of my associates, and he has signed the document saying that that has all been done. So I have, and Ellen Ryan, attorney working on this case, has gone over specifically each and every guilty plea questionnaire. In other words, she did it 15 times, and then Mr. Dahmer would initial each paragraph. And I asked Mr. Dahmer yesterday if that was a fact, and he said it was, but he did me the courtesy of not having to have me read each one of them 15 times. In other words, I've just been told by Ms. Ryan that while she read them to him, he then initialed them, but she didn't read the same thing 15 times. But the paragraph number 1 is the same 15 times, and they were then initialed by Mr. Dahmer, reflecting that he has read them and obviously has had them read to him by Ms. Ryan and by myself.
Okay. Then, sir, you have gone over each and every one of these forms with legal counsel, is that correct?
Yes, we have, Your Honor.
And do you feel you understand what they say?
I do understand.
And as to each of them, there's a signature at the bottom of the front page. Is that your signature, sir?
That's my signature.
And also on the back side, is that your signature, sir?
Yes, it is, Your Honor.
Has anybody promised you anything or threatened you in any way to get you to do this?
No, Your Honor.
Has your attorney advised you of the maximum penalties for these offenses?
Yes, he has.
Did he explain to you that as judge, that I could impose up to those maximum penalties and in fact make the penalties consecutive if I thought it was the right thing to do?
Yes, he's done.
Did he also discuss with you the law in Wisconsin as it exists today regarding parole date, which I guess it applies to 13 of them? Is that did Mr. Boyle explain that to you, sir?
Yes, he did.
You further understand, sir, that when you plead guilty to these offenses, there's a certain group of rights that you're giving up. You're giving up the right to remain silent, the right to confront the witnesses against you, the right to call witnesses on your own behalf, the right to a jury trial, and the right to require the state to prove each and every element of the offense charged beyond a reasonable doubt. Are you satisfied that you understand all of that, sir?
Yes, Your Honor.
Do you have any questions, sir?
No, I don't.
Mr. Boyle, have you had ample opportunity to go over all these matters with your client?
Without question, Your Honor.
The court then finds the plea is intelligently, freely, and voluntarily made. How do we wish to proceed as to the factual basis? We have stipulations in the material submitted.
Is it please the court, I understand basically the confession, the material gone over with Mr. Boyle would serve as the factual basis.